Your Excellencies, distinguished guests, dear colleagues and friends, good afternoon from the Cyprus University of Technology in Limassol, from the UNESCO Chair on Digital Cultural Heritage. I would like to welcome you to this unique event for Cyprus. It is a time when not only our island or our country, but the entire Europe is talking about digital transformation, about the 21st century, which is well known since the pandemic as the century which is going to be digital, in which we had a revolution in the ICT technologies, and especially in the creation of new content, digital content. We, as UNESCO Chair on digital cultural heritage, we are extremely interested to know how we can create content from the past, digitize and publish without having any problems, any challenges in place. As you may know, and is well in the meantime known in this continent, the European Union prepared a directive. The directive had to be now in transition, and of course in the way to be in the status of implementation. The event today is co-organized with our friends from Wikipedia movement, as well as Communia Association, those who are in charge to monitor and see where the member states are so far as the implementation or the transition of the directive are. We are very thankful to the Attorney General of Cyprus, Mr. George Savvidis, to the Minister, Mrs. Nadasa Bilidis, to Dr. Kyriakos Hadjiyannis, the Chairperson of the Cyprus Parliamentary Committee on Energy, Trade, Industry and Tourism. We'd like to congratulate him also for his new job, who is in charge since 1 week, since last week. Dr. Stelios Himonas, Permanent Secretary, Deputy Ministry of Research, Innovation and Digital Agenda. Dr. Christos Cleridis, the President of Cyprus Bar Association. Mrs. Teresa Nobre from the Communia Association. Mr. Dimi Dimitrov from Wikipedia Movement, as well as Mr. Sebu Albert Edwards Foskerician from the Cypriot Photographers Association for their interest and willingness to be with us this afternoon and give us an idea where we are so far as this directive concerned, but what it is needed to be done. And of course, for all the help and support and cooperation so far. But let me please continue by saying, here is the directive and where is Cyprus, where we are as the island, so far as this directive concerned. And then there are two very important articles, so far as us concerned, of course, yeah. The Article 29, the transposition of the directive, and the Article 30. transposition of the directive by all the member states, no exception, by 7th of June 2021, 3 weeks ago. And the Article 30, so far as the monitoring, or the reporting of the European Commission to the Parliament, to the European Parliament and the Council, and of course in the European Economic and Social Committee, which is going to be in 5 years from now, but also in 2 years from now, from the 7th of June, the Commission is going to undertake a study so far the impact of the directive and especially the Article 17. The Article 17 is the most important. I don't want to say anything about that, but it's going to be a part of the discussions coming from our colleagues from Wikipedia and the associate. Now, I don't want to take so much time. I want to thank all of you. And if you are interested and you would like to follow us and be actively involved, be informed on what is happening in this particular area, please, you may like us or follow us on our social media. And we will start with the first presentation coming from welcome and greeting from the Attorney General of the Republic of Cyprus, Mr. Savidis, who unfortunately is not here today with us due to a last-minute commitment. He sent us his video recording, and here is where we are.
Αγαπητοί συνάδελφοι, κυρίες και κύριοι, ευχαριστώντας τους διοργανωτές για την ευγενική πρόσκληση που μου απίφθηναν και συγχαίροντας όλους όσοι συνέβαλαν στην υλοποίηση αυτής της ενδιαφέρουσας πρωτοβουλίας, χαιρετίζω τη σημερινή διαδικτυακή ημερίδα που διοργανώνεται από την έδρα της UNESCO στη ψηφιακή πολιτιστική κληρονομία, σε συνεργασία με το Wikimedia Movement και την έδρα του Ευρωπαϊκού Χώρου Έρευνας στη ψηφιακή πολιτιστική κληρονομιά. Το θέμα που επιλέγηκε για να πραγματευτεί η σημερινή ημερίδα είναι και πολύ σύνθετο και άκρος επίκαιρο, με την πρόσθετη αξία του να μεγιστοποιείται από τον δημόσιο διάλογο που αναπτύσσεται κυρίως εξαιτίας της νομικοκοινωνικής προσέγγισης που διέπει τα δικαιώματα πνευματικής ιδιοκτησίας στο διαδίκτυο και την προσπάθεια προσαρμογής του δικαίου στις τεχνολογικές εξελίξεις. Καθώς λοιπόν το δίκαιο εξελίσσεται, η Ευρωπαϊκή Οδηγία 790 του 2019 αποτελεί τον πρόσφατο εμπλουτισμό της νομοθεσίας επί του θέματος, με την πλειοψηφία των ρυθμίσεών της να αφορά στην ενδυνάμωση των δικαιωμάτων των δημιουργών σε ένα συνεχώς εξελισσόμενο ψηφιακό περιβάλλον, αλλά και στην παράλληλη εξισορρόπηση των δικαιωμάτων όλων των ενδιαφερομένων μερών. Δεν θα ήταν δε υπερβολή να πω ότι η πανδημία του κορονοϊού δημιούργησε πρόσθετο πρόσημο στη δυναμική για προστασία της διαδικτυακής, διασυνοριακής, καλλιτεχνικής δημιουργίας, σε συνάρτηση και με την απόφαση πολλών φορέων πολιτισμού για κοινοποίηση των έργων των δημιουργών στο διαδίκτυο, καθώς και της διάθεσης πολιτιστικής κληρονομιάς στις ψηφιακές πλατφόρμες. Στην περίπτωση του κυπριακού δικαίου, η πολιτεία τροποποίησε το 2014 τους περί του δικαιώματος πνευματικής ιδιοκτησίας και συγγενικών δικαιωμάτων νόμους για σκοπούς συμμόρφωσης με την Οδηγία 29 του 2001, περιορίζοντας το αποκλειστικό δικαίωμα των δικαιούχων πνευματικής ιδιοκτησίας όταν η αναπαραγωγή ενός έργου γίνεται από προσιτές στο κοινό βιβλιοθήκες, επιστημονικά ιδρύματα, εκπαιδευτικά ιδρύματα, μουσεία ή αρχεία και η οποία πράξη αναπαραγωγής δεν αποσκοπεί άμεσα ή έμεσα σε κανένα εμπορικό ή οικονομικό όφελος. Περαιτέρω τροποποιήσεις έχουν επέλθει με στόχο την εναρμόνιση της Κυπριακής Δημοκρατίας με την Οδηγία 790 του 2019, με τις υποχρεωτικές διατάξεις της να διαλαμβάνουν επιγραμματικά τρεις κύριους στόχους. Την προσαρμογή ορισμένων βασικών εξαιρέσεων επί των δικαιωμάτων πνευματικής ιδιοκτησίας σε ψηφιακά και διασυνοριακά περιβάλλοντα, την βελτίωση των πρακτικών χορήγησης αδειών και τη διασφάλιση της ευρύτερης πρόσβασης σε περιεχόμενο, καθώς και την επίτευξη της εύρυθμης λειτουργίας της αγοράς για τα δικαιώματα πνευματικής ιδιοκτησίας. Αυτό στο οποίο θα ήθελα ωστόσο να κάνω ιδιαίτερη μνήα, κυρίως ως πεδίο ανάπτυξης διαλόγου στο πλαίσιο της επιλεγής σας θεματικής της σημερινής ημερίδας, εδράζεται στην πρόνοια της οδηγίας που προβλέπει τη θέσπιση περαιτέρω περιορισμού του αποκλειστικού δικαιώματος του δημιουργού πνευματικής ιδιοκτησίας για χρήση έργων σε ψηφιακές και διασυνοριακές διδακτικές δραστηριότητες, αλλά και στον περαιτέρω περιορισμό της πνευματικής ιδιοκτησίας που προνοείται υπέρ των Ιδρυμάτων Πολιτιστικής Κληρονομιάς, η οποία εν γέννη αποσκοπεί στη δημιουργία αρχείου συλλογών αλλά και εισαγωγής μηχανισμού κατά τρόπον που να παρέχεται η δυνατότητα στα Ιδρύματα να διαθέτουν στο κοινό έργα που βρίσκονται στις συλλογές τους όταν αυτά δεν είναι διαθέσιμα στο εμπόριο. Οι δύο αυτές πρόνοιες εκτιμώ ότι παρέχουν ουσιαστικό υπόβαθρο για σπουδή από τους εκλεκτούς ομιλητές σε συνάρτηση και με το καθεστώς που εισάγεται υπέρ του δικαιώματος των δικαιούχων να δηλώσουν ανα πάσα στιγμή την επιθυμία τους για εξαίρεση των έργων τους από την χορήγηση αδειών μέσω οργανισμών συλλογικής διαχείρισης, όπως τα Ιδρύματα Πολιτιστικής Κληρονομίας ή από την εφαρμογή του περιορισμού της πνευματικής ιδιοκτησίας. Εξίσου ενδιαφέρον πεδίο προς συζήτηση είναι και οι πρόσφατες κατευθυντήριες γραμμές της Επιτροπής προς το Ευρωπαϊκό Κοινοβούλιο και το Συμβούλιο σχετικά με την εφαρμογή του άρθρου 17 της Οδηγίας, καθώς και οι πιθανές επιπτώσεις που θα έχει η αναμενόμενη απόφαση του Δικαστηρίου της Ευρωπαϊκής Ένωσης στην αίτηση της Πολωνίας, που υποστηρίζει ότι η εφαρμογή του εν λόγω άρθρου είναι αντίθετη με θεμελιώδεις ελευθερίες του ανθρώπου, όσοι είναι κατοχυρωμένες από τον Χάρτη Θεμελιωδών Δικαιωμάτων. Κυρίες και κύριοι, τα όσα παραπάνω ανέφερα αποτελούν μερικά μονοδείγματα του εύρους των θεμάτων που η Οδηγία 790 του 2019 διαλαμβάνει και της οποίας το νομοσχέδιο που τροποποιεί την κείμενη εθνική νομοθεσία για σκοπούς εναρμόνισης με το ευρωπαϊκό δίκαιο τη χάνει αυτή τη στιγμή τελικού νομοτεχνικού ελέγχου από δικηγόρο της νομικής υπηρεσίας με εξειδίκευση στα πνευματικά δικαιώματα με βάση τις πρόσφατες κατευθυντήριες γραμμές της Ευρωπαϊκής Ένωσης σχετικά με την εφαρμογή του άρθρου 17. Εξού και η νομική υπηρεσία θα αναμένει με ενδιαφέρον τα πορίσματα που θα εξαχθούν από την σημερινή πρωτοβουλία σας. Επικροτώντας το ενδιαφέρον όλων των συνεργαζόμενων φορέων και συμμετεχόντων για ανάπτυξη συζήτησης γύρω από ένα θέμα άκρος πολύπτυχο, σας ευχαριστώ εκ νέου για την πρόσκληση, ευχόμενος καλή συνέχεια στις εργασίες της ημερίδας και συγχαίροντας σας ξανά για την πρωτοβουλία σας αυτή. Σας ευχαριστώ.
We thank the Attorney General for his speech and interest, but also for his time and availability, even for the video greeting. We would like to reassure them that we will inform his authority, his organization, and his office about the results of the event today. And we will continue with the greeting from Her Excellency, the Minister responsible for the directive, the Minister of Energy, Commerce, and Industry. Unfortunately, again, last minute commitment, the minister was not able to be with us online, but she sent us her video greeting. So here we are.
Good afternoon. I would like to begin my opening remarks by thanking the organizers of today's event, the Cyprus University of Technology representing the UNESCO Chair on Digital Cultural Heritage in Cyprus, the Wikimedia Movement, and Europe Direct Limassol for the invitation and the opportunity to address its esteemed participants. Our world has been transformed by digital technology, and so have our daily lives. Unsurprisingly, digital technologies have completely transformed the way creative content is produced and distributed, giving rise not only to fresh opportunities for innovation, accessibility, and marketing, but also to novel challenges with regards to copyright protection. In recognizing the importance of copyright-intensive industries for the European economy, by 2019, they accounted for 11.6 million jobs and contributed to 915 billion per year, or 6.8% of Europe's GDP. The EU decided to move forward with modernization of its copyright rules through implementation of Directive 2019/790 on copyrights and related rights in the digital single market. By adapting EU copyright rules to new consumer behaviors and leveling the playing field for creators, right holders, and the press when negotiating with online platforms for the use of their work, the goal is to protect end users whilst also rewarding creativity and stimulating investment in the creative sector. Consequently, Europe's overall competitiveness will also be enhanced. Certainly in this complex equation, the challenge is to strike the right balance between competing interests in the digital environment, an area in which new copyright directive is indeed very successful. Back in 2019, when proposing the directive, the European Commission highlighted its four main pillars. Firstly, comes the ensuring clearer digital rights and fewer worries for citizens. For example, online platforms will take care of licensing and citizens will have clearer rights when their content is removed, being able to oppose unjustified removals of uploaded content. Second pillar was securing a better deal for all creative sectors and for the press. Creators in the audiovisual and musical sectors will have increased control over the use of content uploaded by users on online platforms and will be better remunerated for it. Thirdly, the directive aims at fair remuneration for individual creators and journalists, making it easier for actors, musicians, writers, and journalists to negotiate with publishers and producers in order to receive better payment. The fourth pillar is the one more closely related to the work done by the Cyprus University of Technology, and it involves more opportunities for science, education, and cultural heritage. To achieve this, learning, research and development, and the digitization of cultural works are all enhanced, in parts due to EU-wide mandatory exceptions to copyright rules. For instance, research and development of artificial intelligence will get a boost through the new exceptions for test and data mining that permit the analysts of big sets of data under copyright, whereas students and teachers will be able to use digital materials and technologies for learning without facing copyright-related restrictions. In addition, European museums, libraries, film archives, and other cultural heritage institutions will be able to digitize more cultural works for future generations. On the basis of the directive's provision, the European Union Intellectual Property Office has also launched on the 7th of June of 2021 a new out-of-commerce works portal intended to enable right holders to better exercise their rights and at the same time cultural heritage institutions to disseminate the works they have in their collections to the general public. The portal is a public, single online platform for works that are no longer or have been commercially or have never been commercially available, but are still protected by copyright and still hold great value for research and education purposes. The out-of-commerce portal will complement the measures already in place for the use of orphan works at European level through the Orphan Works database. Dear participants, there is no doubt that adoption by Cyprus of this European Directive on copyrights and related rights in the digital single market will foster the smooth operation of the digital market in our country. As such, the Intellectual Property section of the Department of Registrar of Companies began working on the relevant draft legislation in 2019. And after all the necessary public consultations were carried out, the bill was then sent to the Law Office of the Republic of Cyprus for legal vetting in December 2020. Its review is already underway and will hopefully be completed soon, at which point we can submit the draft to Parliament for ratification into a new piece of legislation, of course, which the Department of the Registrar of Companies will have the responsibility of enforcing. So we look forward to that happening, and as I said, it will definitely enhance both the competitiveness and the legal framework with regards to copyrights and other intellectual property in the digital world in our country. Thank you very much for your attention. I wish you a successful and productive meeting. Thank you.
Thank you very much, Minister, for your kind words, but also for your video greeting. And we are moving now to the next presentation, coming from Dr. Kyriakos Chagiannis, the chairperson of the Cyprus Parliamentary Committee on Energy, Trade, Industry and Tourism, which is responsible for the directive in discussion. Mr. Chagiannis, the floor is yours. I don't know if you want to share a presentation or if you would like to talk. Please unmute, and here we are.
Thank you, Dr. Ioannidis. Good afternoon. Dear Minister of Energy, Commerce and Industry, Attorney General, Permanent Secretary of the Deputy Ministry of Research, Innovation and Digital Policy. Dear guests, dear researchers, the directive lays down rules which aim to harmonize further union law applicable to copyright and related rights in the framework of the internal market, taking into account, in particular, digital and cross-border uses of protected content. It also lays down rules on exceptions and limitations to copyright and related rights, on the facilitation of licenses, as well as rules which aim to ensure a well-functioning marketplace for the exploitation of works and other subject matter. The said exceptions and limitations seek to strike a fair balance between the rights and interests of authors and other right holders on the one hand, and of users on the other. They can be applied only in certain special cases that do not conflict with the normal exploitation of the works or other subject matter and do not unreasonably prejudice the legitimate interests of the right holders. In particular, the directive contains rules for the collective management of out-of-commerce works or subject matters in the permanent collections of cultural heritage institutions based on non-exclusive licenses for non-commercial purposes. Moreover, it contains provisions to facilitate collective licensing with an extended effect under specific requirements. The directive also facilitates the conclusions of agreements for the purpose of making available audiovisual works, in particular European works, on video-on-demand platforms. Furthermore, it stipulates that any materials resulting from reproductions of works of visual art for which the term of protection has expired are considered to be in the public domain, hence not protected by copyright or related rights. This, however, would only apply where the material resulting from the production additions are not per se original. It should be noted that even though the harmonizing legislation should be adopted and implemented by the 7th of June at the latest, no relevant bill of law has been submitted to the House of Representatives today. While looking forward to its submission, I would like to express the will of the competent Parliamentary Committee on Energy, Commerce, Industry and Tourism to examine the harmonizing bill of law as soon as reasonably possible and forward it to the plenary of the House for approval. Thank you all for this interesting conversation and exchange of views, and particularly Dr. Marinos Ioannidis, the UNESCO Chair on Digital Cultural Heritage and Wikimedia Movement, for organizing this event. I look forward to further enhancing this cooperation. Thank you so much.
Thank you very much, Dr. Hadjiyannis, for your kind words and greetings. We do hope, yes, for the full support of the Parliament, and especially your committee, for a successful approval, but also implementation. We will continue with Dr. Stelios Chimonas, Permanent Secretary, Deputy Ministry of Research, Innovation and Digital Agenda, who is in charge of a very, very important, let's say, a part of the work to be done in Cyprus, especially during the time of the digital transformation. Mr. Chimonas, the floor is yours. Mr. Chimonas, you have to unmute. Yes, thank you.
I just did. Thank you. So let me start again. Good afternoon, everyone. Thank you, Marinos, dear Chairman of the Parliamentary Committee on Energy, Trade, Industry and Tourism, dear President of the Cyprus Bar Association, speakers, ladies and gentlemen. First of all, allow me to thank you for inviting me to participate at this very important event. It is an honor and a pleasure to be joining such distinguished personalities coming together to discuss and address opportunities and challenges arising from the new copyright directive in the digital single market, which is the biggest overhaul in copyright law in the last 20 years. Digital technologies have transformed the way creative content is produced, distributed, and accessed. The new law sets out to adapt and supplement existing copyright rules to ensure they are fit for the digital and cross-border environments of today's society. It is important to ensure wide access to content online, whilst also protecting and rewarding the creators of that content. The new legal framework aims to enhance the freedoms and rights enjoyed by internet users, allow copyright owners to receive the compensation they deserve for their work through licensing agreements, and clarify the framework for the operation of online platforms. While there has been little doubt that EU copyright law needed updating for the digital age, there have been extreme and opposing views on how this is being achieved through the directive. Critics have not been against the idea of rewarding content owners for their work, but they consider the measures adopted in the directive too onerous or restrictive. The major focus has been on the more controversial Articles 15 and 17, where there is a huge amount of speculation as to how these provisions will operate in practice. The key lies in how member states decide to transpose this provision into national law, ensuring a balance between the interests of rights holders, online platforms, and internet users. Content creators must be encouraged to continue to create content and must be adequately rewarded for their creativity, but it is also important to allow access to content online and not stifle it. It is clear that there are still issues to be tackled. Much needs to be ironed out, and only later on will it become apparent how the provisions will play out in practice. The challenge for all of us is to ensure the copyright law evolves in parallel with technological and economic developments and is used to promote innovative thinking and activity rather than impede it. Digital technologies, research and innovation are key elements of the new diversified and more sustainable economic model we are all striving to build. A model that will lead to inclusive growth, a greener environment, and a prosperous society, in line also with the European flagships and the UN Sustainable Development Goals. As an entity responsible for accelerating digital transformation and promoting research and innovative entrepreneurship as key factors towards progress and development, the Deputy Ministry is committed to ensuring that the implementation of this directive will be used to enhance our efforts and empower our people. A number of initiatives that will need to be harmonized with the new directive are already in the pipeline. First, we are in the process of creating our own Cypriot digitized cultural heritage repository, which is expected to be completed by March 2022. In this huge effort, through the National Committee for the Digitization of Cultural Heritage, all relevant partners participate. These include the Ministry of Education and Culture, the Church of Cyprus, the Department of Antiquities, universities, the State Archive, the Cyprus Broadcasting Corporation, the Press and Information Office, and other relevant organizations. The digitized items will be posted on the platform and will be accompanied by their metadata. Second, we are working towards the revision of our national policy on open access to scientific data. As part of this initiative, we will be creating a national open access repository that will connect and enhance existing systems and e-infrastructures and create a single entry point for open science in Cyprus. Third, the Deputy Ministry is working closely with the Ministry of Education to set up an organized and efficient digital education and learning environment within the public school system necessary to improve the resilience of our educational system and, of course, the overall resilience of our society to any adverse situations such as the recent COVID-19 crisis. Fourth, we are reviewing our innovation and startups framework. Cyprus enjoys a fast-growing research and innovation ecosystem featuring high-quality academic and research institutions and a flourishing startup community of more than 200 enterprises and 4,000 entrepreneurs. To unlock our full potential and position Cyprus as a regional tech and sciences hub, empowering our existing businesses and attracting further ones, we should ensure conducive institutional and regulatory framework conditions and enable researchers, entrepreneurs, and creative minds gain access to resources that include cutting-edge infrastructure and facilities, knowledge, finance, and human capital, so as to be able to build innovative enterprises that are willing and able to enter the international market with innovative products and services and thrive. Dear friends, we are enthusiastic about Europe's future, which is directly related to digital technologies and innovation. Therefore, it is clear that we should all work together to make sure that this future will benefit our people, our enterprises, and our communities. In this respect, we need to ensure that intellectual property is protected and user privacy, freedom of expression, and creativity are also safeguarded. To conclude, I would like to congratulate you once again for the initiative to organize this enlightening and at the same time thought-provoking event. I'm confident that today's deliberation will be useful and productive for all. Thank you very much for your attention.
Thank you very much, Dr. Himonas, for your kind words and for your grading and contribution. It is really very interesting to see where Cyprus is at the moment and what is coming in the near future. We will continue with Dr. Christos Clearidis, the president of the Cyprus Bar Association, for his grading remark. And would like here to say, Mr. Clearidis, this is the first time that we are collaborating with you, and we are looking forward to see you in person here in Limassol at the university, but also in one of our next events related to this issue. I have to underline that this is the second event that we are organizing. The first one was 2 years ago in Nicosia at the auspices of this Cultural Foundation of the Bank of Cyprus. Mr. Kleridis, the floor is yours.
Thank you, Dr. Ioannidis. I thank the BAC for the invitation. Distinguished guests, ladies and gentlemen. I'm going to be rather short and specific. As a bar association, we have created a number of specialized committees dealing with various subjects, one of them being copyright, with Mr. Sozos Theodoulou having been appointed as the president of the committee. In view of the fact that it may be that human rights are involved, as we have heard, in the process of implementing the directive, it may be that Mr. Achilleas Dimitriadis, whom I saw in the list of participants, who is the president of the Human Rights Committee of the Bar Association, may also have to be involved. As a bar association, we will offer all necessary technical assistance if and when required, certainly at the stage when the bill will be before the House of Representatives committee. We are almost invariably invited there for our comments, and we will certainly offer them and try to be productive. We only hope that the directive, which is overdue as far as Cyprus is concerned in its implementation, will be put before the House committee in the field and be forwarded and discussed as soon as possible. We are already running late, and we don't want to have another caution by the Commission for failing to adopt the directive in due course. I note from the subject matters in the event today how to protect freedom of expression and safeguard user rights when implementing the new directive, a very interesting and challenging subject. The race to transpose the copyright directive, how is each country faring? Here we'll have, I suppose, a comparative table of the process of implementation of the directive. And then, of course, the protection of photographic documents, a challenge for the Cypriot copyright legislation. These are very important subjects. I wish to congratulate Dr. Ioannidis for taking the initiative. We are, of course, at your disposal. We have experts in the field, and we will be glad to assist in the quick implementation of the directive in a manner that will conform with human rights, fundamental rights, and will not be objected to by human rights activists. I thank you once again, and I hope that your deliberations will be very fruitful. Thank you very much for the invitation.
Thank you very much, Mr. Kleridis, for your kind words, but also for your time and interest to be here with us and share with us also the latest activities from the Cyprus Bar Association. It is extremely important for us as Cyprus, and of course, from here, from Limassol, from the UNESCO chair, is what I would say is that cultural heritage. It's the heavy artillery of Cyprus. By digitizing in the 21st century all this knowledge, all these stories, and bringing them online, it's for us a big advantage. But on the other side, we have to respect and follow up the rules, the legislation, and of course, all this what is coming from the Article 17 of this directive. And for that, thank you very much for your support. We will keep in touch. And I'm sure Mr. Dimitriadis, who is now online and follow us, and who is a very good supporter, will join us in this, let's say, adventure. Thank you very, very much once again. And we will move to the next guest, and it's an honor to have with us today Mrs. Teresa Nobre from the Comunia Association, which is actually the legal entity in charge for follow-up and monitoring the activities in this area. Teresa is an attorney at law based in Lisbon, in Portugal, and from there is where she is joining us. She is now going to give us not only an explanation of what it's behind in this directive, but also show to us the one way, I will say, that we have in front of us to move forward. Teresa, thank you very much. Having you with us, the floor is yours.
Thank you so much, Dr. Ioannidis. It's a pleasure to be here. I think I'm able to share my screen. Let me try to do so. And
yes, coming.
Yeah. Okay. So I want to focus on the, of course, as my title mentioned, on the parts of the directive that concern users' rights, and particularly on the provisions that are aimed at protecting fundamental freedoms, such as freedom of expression. And I think the speakers before me already highlighted that this is a directive that contains various provisions. We know that Article 17, the so-called upload filters provision, was the most talked during the discussions in Brussels. Article 15 on the press publishers' rights was also very well discussed. But then there are other aspects of the directive that are worth mention and that are really important to protect and to achieve a balance between copyright and the interests of copywriters' exclusive rights, in the interests of authors and right holders, and the interests of the public, of the users, of the cultural heritage institutions, of the educational establishments, research organizations, etc. So as it was already mentioned, and I think I will focus my presentation mostly on the users' rights safeguards in Article 17, but I would also like to say a few words about the implementation of the new mandatory exceptions, as it was mentioned, the ones on digital, education, text and data mining, preservation, out of commerce works. And my colleague Dimi will also focus a bit the public domain protection in Article 14, and also the perspective of the users with regards to these new press publishers' rights, so the limits and the exceptions that will protect freedom of expression and the flow of information and communication online, despite this new layer of rights. So starting with Article 17, it's indeed been a very polemic decision, and I think I would like to mention that although Cyprus has not accomplished the implementation before the legal deadline, we should also mention that the Commission itself, only 2 days before the deadline, released its guidelines on how Article 17 should be implemented. And these guidelines are fundamental to achieve a minimum, or try to achieve an harmonization in terms of the implementation of this provision. So I don't think Cyprus made a bad decision, if it was a decision or if it was just a consequence of the pandemic, because we also know the pandemic delayed many legislative processes. But I don't think it was a bad decision insofar that now we have a guideline from the Commission, and Cyprus has the chance to follow those guidelines. So I think it's actually good that you didn't implement before June 7th. As it was mandated. And I'm sure the Commission will not go after the countries that have not implemented by June 7th, precisely because the Commission itself was delayed with those guidelines. So I think the most important, from the users' rights perspective, the most important thing to bear in mind is that what Article 17 does is to change the rules for platforms, the rules for liability of platforms, as these platforms were not considered liable, and our online platforms in general were not considered liable for the content that was uploaded by the users that could infringe copyright, if they didn't have actual knowledge that the content was infringing copyright. So this is the hosting safe harbor in Article 14 of the e-commerce directive, and that we just had recently, last week or 2 weeks ago, a decision, or last week actually, a decision by the European Court of Justice that really reinforces this idea that in general, platforms are not themselves communicating to the public the content that originates from their users, that's uploaded by the users. So if they don't have actual knowledge, they are not infringing copyright. So what Article 17 does is to change this. That's still the rule for many platforms, but Article 17 creates a new set of rules for certain for-profit content sharing platforms, where these platforms now are considered to be themselves sharing content. So it's not that the user, not only the user that shares content or communicates to the public the content, the platform, when giving access to those uploads, is also considered to be engaging in a copyright restricted act, so in a communication to the public. And because now they are considered to be communicating to the public, they need permission to give access and to make that communication to the public, and they are liable for any uploads that infringe copyright. So in order, and we know that not all content is available, or that platforms will not be able to get permission from all copyright owners, because that's also impossible to go after all the copyright owners before the content is uploaded and knowing beforehand all the content that's going to be uploaded. So we know for sure that platforms will not be able to get permission from all copyright owners. So what the EU lawmaker did was to create a serious set of preventive measures to avoid liability. So platforms still have the chance to avoid liability. And this includes not only trying to get permission, but also if they are not able to get permission, this includes showing best efforts to block at the upload stage specific infringing content that has been identified by copyright owners. So it's an obligation of best efforts to try to block at upload infringing content. But of course, we have copyright exceptions, we have parodies, we have pastiche, caricature, quotations. There's various of uses. We have also works that are not covered by copyright or that are already in the public domain. So the EU lawmaker said in Article 17 that at the same time that the platform needs to block infringing content, it cannot block content that is not infringing. So, and this late obligation is an obligation of result. They cannot block uploaded content that doesn't infringe copyright. And I'm saying this is an obligation of result that prevails over the best efforts obligation. So if there's a conflict between blocking content that is infringing and not blocking content that is not infringing, the later obligation of not blocking content that is not infringing prevails over the first best efforts obligation. And this is clarified by the Commission in the recent guidelines. So how do platforms are able to do one thing and the other at the same time when they are receiving massive amounts of uploads at every hour? Naturally, we all know that the only way to deal with massive amounts of content is possibly through the use of automated content recognition technology. So although the Article 70 doesn't say that filters will be used, everyone knows that filters will be used because it's the only way of managing those massive amounts of content. But the problem with this type of technology is that this technology is very good at identifying content, but it's very bad at identifying context. So the automated filters are able to match, are able to look at an upload and very quickly match that content to content that is copyrighted and that is being identified by copyright owners. But they don't know, so that the filters are not able to understand if the use that is being made of that content is a parody, a caricature, or other legitimate use. So they understand content, but not context. And this, of course, if the platforms are going to rely on filters to manage these mass amounts of content and to block infringing content and not block non-infringing content, this will lead necessarily, if there's no other safeguards, to overblocking of legitimate uploads and namely interfering with fundamental freedoms such as freedom of expression because of this incapacity of upload filters to understand context and to understand when a use is legitimate. So the Commission, and it's really unfortunate that during the discussions that led to the approval of this provision, no one really tried to understand what upload filters could do, what technology could do. I think Article 17 just assumed, or the Article 17 lawmakers just assumed that upload filters could do all of this. And during the stakeholder dialogue that took place after the approval of the directive, a stakeholder dialogue that then led to these guidelines guidance that were that was just released by the Commission less than 1 month ago. So during this stakeholder dialogue, the Commission realized, yes, we cannot just mandate all of these and not design a mechanism for platforms to understand how to do one thing and the other that is conflicting at the same time without, how can they comply with both obligations without infringing the other obligation? So one of the things that the Commission said was in the guidance is that one thing is clear, it's not enough to just restore legitimate content ex post, so after it has been blocked. There is indeed a complaint and redress mechanisms that platforms have to run after a blocking, but that's not enough to deal with the legitimate uses. Platforms also have the obligation, and this comes out from another provision, which is Article 17.7, have an obligation that's an ex ante obligation before the blocking to not prevent the availability of content that doesn't infringe copyright. So how do we design this practical mechanism? The guidance offers some guidance on this design process that member states will have to engage on. So the principle is that the Commission is proposing is that automated blocking should be limited to manifestly infringing uploads. Only if an upload is manifestly infringing should the upload be blocked. So, and the relevant criteria to determine if an upload is manifestly infringing or not will, of course, need to be set by either by the lawmakers or by the platforms, ideally by the lawmakers, so that we have some control on the technical criteria that's going to be used to make those decisions. And this is not a final decision. So this is just a criteria to understand what should be blocked immediately and what should not be blocked immediately, because then we still have a complaint and redress mechanism where a person will make a final decision. Final, of course, that's subject to court reviews and etc. But it will make a decision on whether the blocking is infringing or not. So this is just a technical and a first stage to make this first decision whether to keep the uploads online or not. So this is the principle. There's one exception to this principle, which is time-sensitive content that's been signaled by right holders. So right holders, we need to justify why a certain upload would cause significant economic harm to them, and they could lose the ability to earmark content if they abuse of it, but this would be the only exception. So, for instance, if we are, if a new film is being broadcasted for the first time, while the film is being broadcasted, it's still very time sensitive. We don't want the film to be uploaded to YouTube while is being just communicated to the public for the first time. So that was the thought of the Commission. So it created this exception for time-sensitive content. Otherwise, just manifestly infringing uploads can be blocked. Then, of course, we still, as I said, we still have the complaint and redress mechanism ex post, where the content that is not manifestly infringing or not earmarked should stay online during the human review. And these complaints must be processed without undue delay. So with this in mind, and then I think this flowchart is interesting for you to realize what's the thought here. And we will look at the Commission's guidance, but also at the German implementation, which so far is the only country that has implemented the Article 70 in a way that is compliance with the Commission's guidance and in a way that is compliance with, or tries to be compliant with fundamental rights. So if you look at this flowchart, you see the idea is there is an upload that the filters match with the work. And then there's this first decision. Is the use manifestly infringing, following a criteria that will need to be defined by member states, but that the Commission already offers some examples of what it could be. So for instance, if there's a combination of different works, that normally would mean that it would indicate that's not a manifestly infringing work. If the use is not work in its totality, so it's just a part of the work that is used, that's also an indication that it's not manifestly infringing, etc. We will see that Germany created really further standards to identify when a use is manifestly infringing or not. So if it's manifestly infringing, of course, the automatic blocking is permitted. So what we are talking here is a bit of a division of the risk of something going online or not going online. So that's the criteria to divide the risk. If the use of the work is not manifestly infringing, in principle, it should stay online. It will only not stay online if we are talking about time-sensitive content that has been earmarked by the right holder as having the potential to cause significant economic harm. So in that case, it will be blocked. It will not go online. But if it's not that case, then it will stay online. Of course, after these first initial decisions, whether the filters automatically decide if it stays online or not, the parties still have the chance to oppose, and there's a complaint mechanism and redress mechanism, and then we'll have a final decision by the platform. And if in the end it finds the use of the upload to be infringing, it takes it out. If it finds the use to be legitimate, it keeps it up online or reinstates it if it already had taken it down. And of course, the parties can still go to court afterwards. So the German implementation, as you will see, it's very, very similar. And the only, I think the main differences are already that the lawmaker defines which uses are presumably authorized by law. And it has various criteria, namely, it has this idea of minor uses where, for instance, the use of 15 seconds of a cinematographic work or 15 seconds of an audio track are considered to be minor uses and presumably authorized by law. And there's more criteria, so this is in addition to using only parts of a work, and in addition to combining that use of a copyrighted work, of a work of a third party, with something else, so content of the own of the user himself, or content that's not protected by copyright, etc. So another interesting thing is that the Germans created this concept of presumably authorized uses that stay online and cannot be automatically blocked. But they say that this concept doesn't apply to those works, cinematographic works, where they are still being communicated to the public for the first time. So the example that I gave, that for the first time the film is being exhibited, during that time while it's still being exhibited, this concept doesn't apply. There's also another safeguarder for right holders. So trusted right holders have a red button, the possibility to say, even if the use is considered presumably authorized by law, we think that's actually evidently infringing and could be commercial harmfully. So we ask you to take this out immediately. So it's the second step only for certain trusted right holders, and where is the risk of economic harm. So very close also to this idea that the Commission put forward. And that's it. Then we have, of course, the complaint decision, etc. And depending on that final decision, it stays online or it is blocked. There are, I don't know if I still have time to comment a few more things. If I have, otherwise let me know. I would say a few other things about Article 17.
Teresa, take your time. It's a pleasure to have you with us, and it is of great interest, all this what you are explaining here at the moment. So therefore, please take your time. We can extend and go beyond 5 o'clock, yeah, local time. Thank you,
Marinos. So, I'm sorry. So I did take my time. I'm sorry. So other important things on Article 17 are the definition of the platforms that will fall under Article 17. So we want to have a target definition of these online content sharing service providers. And because Article 17 was not intended to cover all platforms, just profit-making platforms that allow users to upload and share large amounts of protected content, and very importantly, that compete with other services in the online content market. So this number 3 comes from recitals 62 and 63. They are not on the text of Article 17, but they are extremely important. Okay, so and actually the German implementation has implemented this exactly this wording from the recitals, and it's actually very important because we don't want, the objective of Article 17 is not to cover all types of platforms, so we really need to be very explicit about what it covers and what does it not cover. The idea is to really target these ones that compete with online content services, such as on-demand streaming services. Then we have, Then we have another important issue, which is Article 17.1 about granting permissions to platforms. So Article 17.1 says the platforms need to get permission. But of course, member states can provide for different authorization models. So the permission could be an individual license, but member states can also decide to facilitate the granting of authorizations instead of just relying on individual licensing. And the Commission gives some examples. So we have voluntary collective license, extended collective license, but also, and the Commission is not, the guidelines are not clear, eventually mandatory collective licensing. So the idea is, if you rely on collective license, you will probably get more permissions, and it will be easier for platforms to deal with this amount of content that's uploaded by users. And from the user's perspective, is of course much better when the platform has a permission than when they have to rely on filters. Of course, the users will be, as we saw, at greater risk when they rely on filters. So that's important. And another thing that's important is creating standards to assess whether the platform has complied with obligations of best efforts to obtain permissions from right holders. So the idea that the obligation to get permission from right holders is also an obligation of best efforts. So what does that mean in practice? Should platforms go after each and every right holder that exists and potentially exists on Earth? That's of course impossible. So the guidance from the Commission gives some ideas of measures, of standards for the platform. So it says that at least the platforms should proactively go after those right holders that can be easily identified and located. So especially those right holders with broad catalogs. So think about the big, think about the collecting societies that have catalogs, of course, but also eventually think about the big Hollywood producers or music labels. So this could be right holders with broad catalogs. Of course, large platforms probably have to seek a higher number of right holders than smaller platforms. And at least what the Commission says is that they have to seek right holders that are representative of the content that is predominant on their services. So content that is not predominant on their services, they don't have to go after those right holders. But, and that's actually something that the Commission guidelines also clarify, even if the content is not predominant on their services, if the right holder itself reaches out to the platform with an offer to license that type of content that is less common on the platform, the Commission says that the platform needs to engage, in discussions with that right holder. Of course, there's a question of whether the platform has to accept a license for content that doesn't appear, it's not so common on the platforms, because the platforms also have some freedom to conduct their business, and they should be able to decide what also goes on their platforms or not. And if they don't want to have certain types of content on their platform, and it's not common to see that content on their platforms, of course, they should probably also have the freedom to say something about it and not to accept a license. But the guidance is not clear in that aspect. For smaller platforms, namely platforms that only have like a national focus, the Commission says that they must seek at least permission from collective management organizations, I would say from collective management organizations in their countries, of course, and perhaps just a few other easily identifiable right holders. One important clarification is that the platforms do not have to accept unfair or unreasonable licenses. And one interesting suggestion that comes up in the guidance is that suggestion that member states should encourage the development of registries of copyright owners, so of databases that could be consulted by platforms. We actually think that's very interesting, of course, because it's impossible to know who owns what and where those people are located. So this idea of databases could be very interesting, and also very interesting for the Commission itself. And I think the Commission is really trying to at least start a discussion at the EU level of this idea of registries. So finally, and for Article 17, of course, there are other mandatory users' rights safeguards that are equally important, namely the ban on general monitoring. So general monitoring is not permitted. The way we transpose and apply Article 17 cannot lead to general monitoring, and the national law needs to be clear about it. Another aspect is the mandatory copyright exceptions that appear in Article 17, in Article 17.7. So Article 17.7 creates new mandatory exceptions for quotations, criticism, review, caricature, parody, and pastiche. And the Commission also says that member states can and should perhaps implement optional exceptions that exist under the InfoSoc Directive, namely the incidental use exception that's very, very important for users' rights and for freedom of expression. So, of course, if member states do not yet have these exceptions in place in their countries, this quotation, caricature, parody, they should implement these exceptions for all types of uses and not just for uses in this type of platforms. Imagine now you would be able to use this on these platforms, but not on the Wikipedia. That would not make any sense. Or you would be able to use these exceptions online, but not offline. So of course, this is not recommended. What Article 17 says is that at least this is mandatory for these uses on these platforms, but of course, member states should be, and the national lawmaker should make a reasonable decision here and implement these exceptions as they exist in the InfoSoc Directive for all types of contexts, and not just for these platforms. Another interesting thing, and the Germans did this, and we highly recommend to do this, although the guidance, of course, and Article 17 itself does not mandate, is measures against abuse. So Germany has decided to sanction abuse of rights under Article 17. So if the right holders abuse of their rights to claim ownership, so if they make false claim ownerships, they say this content is mine, but this content is not theirs, this is the content that's already in the public domain or that belongs to a third person, or if they abuse of these red buttons, that's to say that my content is very highly sensitive and economically significant, etc. If the platforms themselves also abuse, all of that should be sanctioned. And the platforms should also be required to publish transparency reports on their practices, because that's the only way to allow consumer organizations to challenge the practice of platforms, namely challenge the technical parameters, etc. So I think Article 17 also gives us an opportunity to improve the user's protection and the consumer protections in the online environment with regards to these platforms. So national lawmakers are very much recommended to make use of this chance. So I will leave this slide. There's many different types of user safeguards, as I mentioned. And I would end up with the last slide moving out from the Article 17 and to the mandatory provisions that we now have on the directive. I would just have a last slide to say one thing about Article 3, 5, and 7. So Article 4 and Article 8, they have exceptions that are completely new. So lawmakers need to kind of try to implement those exceptions as best as they can, but they have to follow the conditions of the DSM directive. But then we have Article 3, 5, and 7 that deal with text and data mining for scientific purposes, educational uses, and preservation, which are exceptions that are now mandatory, but they only create a minimum standard, a minimum set of mandatory provisions, because member states, if they want, and this is clarified by Article 25 of the DSM directive, so member states, if they want, they can still, for these 3 exceptions, have broader exceptions in place, because those uses were already allowed under the InfoSoc exception. So the InfoSoc exception already allow text and data mining for scientific purposes, already allowed digital education, already allowed preservation, and allowed it, especially for education and research. The exceptions that exist in the InfoSoc, they are much broader than the ones that are foreseen in the DSM. And the idea of the lawmaker with the DSM is not to narrow down the exceptions that already exist in the member states, is to open up those exceptions. So if you have exceptions that are already broader, do not replace them with those ones from the DSM directive. So, and if you have exceptions that are already broader, do not implement the new exceptions, because that would create an overlap between existing exceptions and the new ones. So the new ones are really for those member states that had not those exceptions in place before, or that had more limits than the ones that are set by the DSM directive. So keep that in mind, because I think that's very important to preserve the rights of the education and research communities in your country. Let's not make things worse, let's make things better for those communities. And that's all. Thank you so much. And I'm sorry for taking more time than probably I had under my 20 minutes. I don't know, I kind of lost track of it. Thank you so much, Marino.
Thank you very much, Teresa, for your kind words, but also for the excellent presentation. It was up to the point. It was what it is, but also what are the duties, the advantages and disadvantages, and of course the exceptions, especially in our area of work, the education and research. Thanks a lot, Teresa, and we do hope to continue have you with us in the next meetings, virtually or even physically on the island. Yeah, we are moving to our next speaker, Dimitrov, who is coming from Bulgaria, but he's a political scientist who works as free knowledge ambassador of the Wikipedia movement in the EU. He is located in Brussels, and he's going now to give us an update of following the presentation of Teresa. Will update us with something which is extremely important. Dimi, the floor is yours, and I'm looking forward, Teresa, also Dimi, to the follow-up and discussion at the end.
Yes,
Dimi?
thank you. Let me just share my screen.
Yes, please.
Just a second. I don't know whether it works now.
It looks like it's loading. You are in a place with a very low bandwidth, Dimi. But
oh, wow.
It looks like loading.
Okay. Well, I'm in Brussels. There should be decent bandwidth here, but you never know.
There are several people in Brussels. You are not alone. It's actually Europe in Brussels. And not only. NATO is also there.
If you want to share with me, Timi, I can present. If it doesn't work, I can.
Yes, or with us, Timi, yes, there is no problem. But depends.
Okay, so I should send you the presentation, Teresa, is that it?
Yes.
Probably, yeah.
I think that's the best, Timi. Something which is very important, and I have to mention it, is that we are recording the meeting, and we will have it available. Teresa, I don't know if this is allowed or not, according to this directive, on our YouTube channel, which is available via the website of the UNESCO chair of the lab. And we will inform, we will send the link to everybody. It is a unique and important event for Cyprus, not only for the government, for the policymakers, for the civil servants, but and all those who are in charge of that, but also for the industry, for the creative industry, especially, and so on. Yes.
I believe it worked now, right? Okay.
Yes, the floor is yours.
Thank you. So we at Wikimedia are very focused and keen on digitizing cultural heritage and making it accessible and reusable for as many people as possible. So basically worldwide. So it comes to little surprise that one of the very few unambiguously great articles for us in this directive is under Chapter 4, Article 14, which basically deals with works of visual arts in the public domain. It's also maybe worth mentioning that it's the first time the term the public domain appears in EU law, or at least that I know of in a directive. So we're quite proud of it. Now, what does Article 14 say? It says that once the protection of a work of visual art has expired, any material resulting from an act of reproduction of that work that is not subject to copyright or related rights, unless it is a new creative creation. Now, why is there such an article with its own chapter in this directive? There is a very concrete case that happened to us. And it is this painting was the main reason. This is a portrait of Richard Wagner, painted by Cäsar Willich. Cäsar Willich is a German painter who died in 1886. And since Mr. Willich has been dead for longer than 70 years, we at Wikimedia and our volunteer editors considered this picture of that picture public domain and used it to depict the article of Richard Wagner on Wikipedia. Now, the German museum that owns the original was unhappy with that. So they sued against Wikimedia and ultimately won in Germany's highest court after several years of legal procedures. The reason is that while the copyright may have expired, the museum claimed it had a related right on the image of this painting. And since nobody else is allowed to make a pictures inside the museum did not allow for the use of this image based on its image rights. Which we thought is unfair, and we approached the EU lawmakers about this, since we think that cultural heritage needs to belong to all of us. This article was included, maybe to break it down a little, which public domains works are covered by Article 14. So the Article 14 only applies to visual art. We don't know exactly what visual art is, but normally this should include paintings, drawings, photographs, sculptures, architectural works, design works, ceramics, crafts, and murals. It also what is covered is also works whose copyright term has expired. This is also important. So what are the conditions imposed by Article 14? So on one hand, it needs to have expired copyright, and then again, the reproduction needs to be basically a faithful copy and not a new creative version of it. There are like some member states, like the Netherlands and Belgium, decided not to transpose this article with the reference that this is already the case. So whatever it has expired copyright has no new protection of it, and they don't seem to think they have related rights that can lock in works that should already be public domain. We respectfully disagreed, but anyhow, this is how those countries went along. But I want to show you how two other countries looked at it and decided to transpose it, or are in the process of transposing it. So for once, I have the government draft of the Bulgarian Ministry of Culture for the Copyright Directive. And in Bulgaria, under Article 4, there are several things that are a priori excluded from copyright. And since in Bulgaria, the related rights are attached to copyright, also from the related rights. So you can see that we have normative and individual acts of governments, ideas and concepts, folklore, news, facts, information, and data. And here is where the Bulgarian government decided to add a 0.5 that basically says material obtained by reproducing works referred to in Article 3, which means basically works of visual art with an expired term of copyright. So basically a quite neat exception from any copyright or related right, because it says it just doesn't exist for these works. We can also look at the German transposition, because the German government already actually adopted the whole transposition law. There they introduced a new section, section 68, that is about reproductions of public domain visual works, as they say it, as they defined it. And there they basically focus on the following. They say reproductions of public domain visual works shall not be protected by related rights. And why did the German government not also, like, say, by copyright and related rights? Because for the German government logic, like, if your copyright term has expired, then you don't have copyright. There is no extra need to state it, as, for instance, the Bulgarian government decided to just clearly make sure that copyright is also excluded. So two different approaches. I think the clearer and the less ambiguous, the better. In this case, I would rather, I guess, prefer the Bulgarian option. And another thing that I wanted to show you also how it can be implemented is the press publisher's right. So the press publisher's right is basically a new layer of protection that is supposed to help European press publishers, such as newspapers and magazines, monetize when their works get shared on online aggregators or social media platforms. This is the goal of it. So it gives press publishers basically an extra right for their, let's say, articles on online platforms. And I think it's good to break it down a little. Which rights are granted to press publishers. So the directive gives press publishers the exclusive right to authorize the reproduction and making available of their publications by information society service providers. So this new right only covers information society service providers such as online platforms, but not, let's say, traditional service providers or traditional printed media. The next question would be, which press publishers benefit from the new right? And there it's very clear: publishers of press publications established in a member state of the European Union. So if you're a publisher of, or if you're reusing works of a publisher from the US or Australia, you do not need to worry about this new exclusive right, because it does not apply. And then the third question is, which publications are protected by the new right? And there, the directive is quite, goes over lengths to sort of explain what is protected and what is not protected. But it basically says that press publications are defined as mainly literary works of journalistic nature, and which constitute an individual item within a periodical or regularly updated publication under a single title, such as a newspaper or a general or special interest magazine. So this is the main thing. So basically, we're really talking about newspapers, magazines, and then their articles. However, the directive also does the inverse exercise, and it elaborates, it lists either in the articles or in the recitals a number of things that are explicitly not covered by this new exclusive right. These are individual words and very short extracts, and it does not define what very short extract means, but basically, if you just take a little bit of, I guess, a couple of words of an article, that should be fine. It explicitly excludes hyperlinking. It explicitly says that private and non-commercial uses by individual users should not be included. Basically, it also says that non-exclusive licenses, such as free licenses, which Wikipedia is under, uses under copyright exception, and mere facts and public domain works should also not be hindered under this new layer of protection. So it seems like there is a circle to square, like how do you prohibit some uses but not others in national law? Again, we can look at the Bulgarian government draft, which is about to be communicated to Parliament in a couple of weeks' time, probably. The Bulgarian Copyright Act is going to get a new Article 19, which says the publishers of publications in the press shall have the exclusive right to cede to information society service providers for remuneration, the right to online reproductions, and offering electronic access to publications or parts thereof. So this is the main article, but what is maybe a bit more interesting is that it also lists what this thing does not apply to. So it really says the acts of individuals for non-commercial, of use of individuals for non-commercial purposes, reproduction of facts, the use of single words of very short extract, or creating references, hyperlinking, are explicitly not under this scope. It also says that works published in periodicals for scientific and academic purposes, which is part of the directive, is also not part of the scope. And what is perhaps very important and very good is it also explicitly says that blogs and sort of personal sites that are under, of course, the initiative or the editorial control of a user and not of a service provider of an ISSP also don't fall under this. Maybe what is interesting for authors, because the idea of this new related right is that the remuneration gets shared between journalists and press publishers. So I'm sorry, there are a few more exceptions in the Bulgarian law, like what it does not apply to. So it really goes, it mentions non-exclusive licenses such as Creative Commons. It also says that you know, if you include other works in your press publications, then they're not covered. And it's really exact and explicit about all the things that are not included. But what it also does is it says that if
λέει μας ότι η επιστολή ημερομηνία μας 22 είναι τουλάχιστον παραπλανητική για την επέκταση του κοινωνικού. Αλλά να μιλήσω μετά να σου εξηγήσω ότι έγινε Νικόλα.
Excuse me, can you please mute your microphone? Excuse me.
Yes. Okay. So it basically says that.
Sorry for that, Dimi.
No worries. So what also the Bulgarian implementation of this press publishers' right solves, it says that if there is no other contract between a journalist and the press publisher, so the author and the press publisher, then 20% of the income goes to the authors of the work. So let's say the journalist who wrote the article, and 80% go to the publisher, so let's say the newspaper. Which might be a lot or not enough, but at least there is a clear split already foreseen by the law. I think what might be interesting for the people participating in the seminar is also how the implementation is progressing in different member states. That's why together, I mean, the Comunia Association, with a little help from Wikimedia, of course, built a tracker, which is accessible under tracker.comuniaassociation.org. And if you go there, you will see the different EU countries plus Norway, potentially one day also Iceland and Switzerland and Liechtenstein. And you will see that 3 countries have adopted the directive. The Netherlands, Hungary, and Germany. 2 countries have adopted only parts of the directive. And for the most countries, it's either a publicly available law or in parliament, or there is still an ongoing process at the government level, basically an inter-service consultation or a ministry working group working on this. Now, if you go to this website, you can also click on each of these countries, and then you will see, this is, for instance, which country is this? This is the Danish page. So in the Danish page, we try to gather everything we know about the process in this country, and you can also see how the text changed and which parts were proposed and whether there was a public consultation and what position some stakeholders contributed. So we really try to gather as much known information as possible about each member state, because we think it's interesting also to compare, but also to know what's going on. So please, if you know more things about Cyprus, don't hesitate to also drop us a line and maybe even a document. Another thing we built, because of course showing a lot of information on each process is very interesting, but not always that much fun. So we also built a mini site called eurovision.comuniaassociation.org, where we basically took the idea from the Eurovision Song Contest that each country receives certain points based on how it transposed the directive. And we rank them and we say why some countries got points or not. Now, if you see your country here, Cyprus, and it's not yet in a bright color, it's just because, of course, the 3 countries that have transposed it have already been marked with all the points, and the others are sort of preliminary marked. But we will be updating this as we go. And for us, it would be interesting to see from our perspective which country scored best in the end. You can see that currently, from our point of view, Germany has done really well. Hungary has gotten decently fine notes, and Italy and France are really not faring very well. Of course, here as well, you can click on each country. And if you click on them, here is the example of Hungary. You will see why and for which activities and for which behavior we gave points to that country. In the case of, well, normally what we look at is the procedure. So was there a public consultation? Was there a working group? Was the government open and transparent about the process? So you can score a lot of points on the process if it's democratic and inclusive. You can score points on, especially on Article 17, if you manage to strike a balance between really user rights and rights holders' rights. And you can get, of course, extra bonus points. In this case, Hungary gets bonus points because it really took notice of the COVID pandemic and the lockdowns, and it very quickly introduced an educational exception that basically makes it legal for teachers and students to use modern technology like Zoom, like Skype, like Viber, or whatever else they use in order to do teaching in classes. Because if you look at most member states' traditional laws, this is not really covered. Such, classrooms on Viber would not be covered. So Hungary took care of this, and this is where countries can score bonus points, of course, on Article 17 in the public domain, but also on other activities. So Eurovision.communiassociation.org for seeing who will be the winner and who can basically take the title of the Eurovision DSM contest winner. And with this, I think I will leave you and leave some time for the speaker after me. Thank you.
Thank you very much, Dimi, for your presentation and all the update, the entire update where we are. I like a lot the way with your patches, and yeah, probably there we can help you, yeah, and we can see what we can do. We are moving now to our last speaker. We are very proud to have him with us today. Mr. Sebu Albert Edward, who is representing the Cypriot Photographers Association. He's a member of the board, but he's a fourth generation immigrant. Sebu, please correct me if I am wrong. Your grandfather was one of the first photographers here in Cyprus. Photography is actually in your DNA.
Yes, very much so.
Is actually this which brings you money, and your existence depends from that and all the rights. Your grandfather did an excellent work. A part of this work is available via our digitization projects in Europeana.
Yes, and, yes, it's an honor.
It's let's say a small window to our past, and yes, we are very proud to have you with us today. Thank you very much, and also for your continued support.
Thank you.
Sebu, the floor is yours, and we are looking forward to hear your observations and, of course, your comments, remarks, and so on. Please.
Thank you, Mr. Marinos, for the invite. It is a pleasure and an honor to be here amongst everyone. And thank you very much for the people who are actually watching and listening to us to this meeting. I am Sebu Voskerician. I'm, as Mr. Marinos said, I'm grandson of the great Edward Voskerician, who was born in Armenia and emigrated in 1914 after the Armenian massacre here in Cyprus. I am fourth generation in my family. I inherited this business, and I learned the art of photography through the hands of my my late father, Albert. As a professional photographer for more than 20 years, I'm representing today the Cyprus Professional Photographer Associations and all my professional photographer friends. Photography has evolved from the days of my grandfather, where they used to use glass negatives. Some of you, the glass negatives are here, as you can see here, this one. And it has evolved from those glass negatives where they used very big cameras to this little chip where you can put it in your little mobile phone and you can store a lot of images on this. At this day and age, things have changed. My day, my digital day, that's how I call it, where any image can be edited, photographed by a mobile phone and sent through social media for everyone to view around the world. This is a very big advantage, a very big technological advantage, as we think, and I'm very proud of it. But unfortunately, this has led to many professional photographers to end their businesses because the competition hasn't been very healthy. As a professional photographers, we are very proud of this new initiative, this copyright protection. It helps us protect our photographic work. It helps us protect something that has been copied and used amongst a lot of people for many years. Anyone these days with a mobile phone can photograph our work, can photograph something that we've actually created, and can, as I said before, can be shared on social media or even on a professional level. And it is very hard for us to actually track this copying. And it has brought us to a very difficult position, as I said before. Without our knowledge, without our consent, anything can happen. This new legislation has helped. This article is a very big step for us forward, and we're very happy and we're very pleased that it is happening. It is happening. On a more personal level, regarding this copyright, I'm very happy regarding my family, because a lot of our black and white photographs, as you can see one behind of Limassol, have been copied and abused in many ways. There are many people who've actually taken photographs of the photographs in public places, which have been displayed for many years, and they're actually selling and printing these things and also sharing them online without any consent. And to my more, let's say, upset, is that they don't even actually mention who the photographer is. This is not only as a personal level to me and my family, but I have a lot of friend photographers, my grandfather's friends, my father's friends, my friends, who actually try and survive, try and make a living out of this profession, whose work is being exploited in a very bad way. We're very happy with this, and I'm very happy to be present today with you. And as a professional photographer, as a member of the Cyprus Photographers Association, we are very happy to be present here and to continue our collaboration and to create something good for our future children. Thank you, Mr. Marinos, and it is a great pleasure.
Thank you, Sebu. Thanks a lot for your presentation and comments and observation. That's interesting. And now we came to the last part of our event, which is the discussion, and then the conclusions. So it will be nice to hear some comments, any other observations, any other remarks from the participants. I don't know if we think with the participants. Yes, Sebu, please go ahead. There is no problem.
I've been taking down a couple of notes, and it's a bit of a mess here, but I am regarding the public domain protection. I'm very happy with what I heard from that. And regarding the social media, because social media is so strong at the moment, any image can be uploaded in seconds and the whole world could see this image. And I see that reading and listening to our great speakers is that this has, before it was out of control. And now I'm very happy to hear that there are some things that are being put to protect, let's say, to what on social media regarding photography and regarding the copyrights and the content. Technology-wise, from my IT friends, from what I hear and from what you've presented here, is it's very difficult to trace, let's say, trace the image so that you can find the content. Am I wrong in this? From what I understood?
Teresa or Dimi, do you want to take a position?
Let me finish on my thought, and Teresa can answer anything because she's put a lot of information in me. I'm trying to put things in context. What I would like to suggest, let's say, as an EU prerogative, let's say something new in the EU, when someone uploads an image, and let's say on the professional level, let's say, when someone uploads an image, most of the people who find an image on the internet and everything else, the content is not there. What if the EU can create somewhere where we as professional photographers can register? Like a good example for me, let's say, in my experience was Europeana. Europeana is a godsend, I can say, for me, because I had images from my grandfather on social media. And when I found out, because I search around different accounts, different everything, Cyprus images, and I personally wrote an email to the, let's say, I'm not going to say which company, but it's a very, very big company, one of the top 3, I can say, who share different images and everything else. I wrote them a good email, a complaint. I have a selection for that. And I used Europeana as proof of these images are my family's, my grandfather's. And I can say I was very happy. In 24 hours, those images were gone. And I had a very, let's say, apologetical reply for them but what if there was somewhere where we could all register as professional photographers, upload our content, the ones that we want people to share, and they could, let's say, or if someone is looking for, let's say, the creator of an image, to have somewhere, let's say, an example which is perfect, let's say, like Europeana, but on a more broader perspective, where people can actually go and search there on a more professional level as well. Not only the heritage, but on the professional as well. Thank you.
Teresa or Dimi, before you take the floor, I would like to comment here something which is extremely important. And it is at the moment under development, but very soon it's coming to be alive and fully implemented. It's the European Scientific Cloud. And under that cloud is going to be a part dedicated to cultural heritage. And that's a space dedicated for the museums, for the galleries, for the libraries, for the archives, and for the creative industry, who wants to use this space for, let's say, archiving and presenting or visualizing their content. It is extremely important to say that the IPR issue, it's at the moment, one of the biggest challenges in this domain, and especially in the implementation of this initiative coming from the European Union. So soon, Cebu, we are going to have a lot of developments in this area. But my last comment here is that indeed, it is a wild, it's actually a jungle. This is what is happening at the moment with content from the past. It's not just only images, there are documents and whatever else. So far as the Cypriot memory concerned, it is a really pity. And the Cypriot Bar Association, the Attorney General, the ministries, those who are in charge in Cyprus, have at least in the public to inform the community, to inform Cypriots how to handle, how to, let's say, work with social media tools. The Europeana success story that you mentioned right now, Sebu, it's an ideal case. On the other side, Sebu, we have to say that something uploaded on the social media on a free of charge to be used social media doesn't belong anymore to you, belongs to the social media, yeah, to the provider of the social media. It's the one can't wash the other, yeah. So I'm giving you free services, you are giving me content, and I do whatever I want with this content as a provider. So we need to be extremely careful so far as that concerned. Before I will go to Nena Tenderini, Teresa or Dimi, if you want to say something.
I can say probably, Marinos. I mean, the problem with the discussions on copyright at any level, let's say national, regional, or international level, is that normally we don't have the voices of the artists, of the photographers, of all the types of categories of right holders. So it's normally certain industries that are represented, so the film industry or the music industry, but then we have the music industry, but we don't have all types of categories of authors and artists represented there. And that means that there are certain views that have been put forward by the right holders that are considered to be the views of the entire categories of right holders, but they are not. So one of those views is that, you know, copyright should not be subject to registration. But we see that probably for some authors, registration would be something good and would facilitate their management of copyright. So I think we need more of those voices as the voice of the photographers. Another voice that normally is missing here in this context is the voice of performing artists that now suffered a lot during the pandemic because there were no concerts. So we need those views, and I agree with you that it could be interesting and good for all parties involved, not only for users, but also for certain authors to have some sort of registration system. And another thing that I thought was very interesting that you mentioned, Cebu, was this idea that Europeana is a public platform. So we mostly rely on private platforms such as, you know, YouTube, Facebook, to have content and to have access to content. But investing in public platforms could be a good way forward for Europe, at least for certain types of content. And there's also people, and namely at Comunia, we have some organizations, some member organizations that have also been putting this idea forward of creating more public platforms, such as Europeana for cultural content. And I think that's, I mean, I'm not sure I have answered to everything, but maybe just clarify what I said in terms of identifying content through content technologies, content recognition technologies, is that the technologies are good at identifying content. So they are good at identifying of photos. What they are not good is at identifying how those photos are being used, if they are being used in the context of, you know, a wider work of citation or that could be protected by freedom of expression or other exceptions to copyright or other fundamental freedoms. So thank you.
Important here, Teresa and Cebu, to mention exactly this what Dimi shared with us earlier, the exception of the hyperlinks. For example, under Europeana, let's say in one of the images that we harvested in Europeana, Cebu, and you shared with the rest of the world, there is the option there that someone can share it in the social media, but they don't share the image, they share the hyperlink. It looks like, it's like a mirror, you know, you are standing in front of the mirror and you see, you know, the reflection over there. But once when the image is active, then you're going back to Europeana. You can follow, the path. And there is where it's clearly stated your rights. And it's clear, all this. But to this, probably what you mentioned, Irini is asking to have the floor. Irini, yeah, floor is yours.
Thank you. Thank you very much. I would like to thank the organizers as well and the speakers for very interesting presentations. Can you hear me?
Yes, and
you
if
hear
you
me?
can say who you are and if you are coming from a...
Yes. Yeah, I am a professor specialized in copyright. I was doing the Greek laws for 12 years, working at the Ministry of Culture of Greece. I have negotiated the DSM directive, and I've been dealing heavily, with copyright and culture heritage. So I would like to give some answers to Cebu. These are very interesting questions, and in fact, there are questions coming up from right holders all the time. As international copyright system stands today, there is no registration. That, of course, as Teresa mentioned, does not mean that registration is not something which is useful and something we should perhaps be pursuing in order to be able perhaps to also identify the public domain. However, there are chances where you can in fact submit a work in order to get what we lawyers call a certified date. For example, in Greece, what we have done when I was the Director General of the Greek Copyright Organization, we have set up a system of certification where you could in fact submit your photograph and you could get a certified date in order to know when exactly you submitted the photograph. That created the presumption that you're the author without, of course, being in a position to certify that you're the author indeed. So Europeana is not a system of registration. It's something your lawyers could perhaps use before a court in order to show and bring proof that this photograph belonged to you or to your father, etc., etc. So the fact that there is no registration right now, it has an argument that it is there, in fact, to help right holders in this respect. However, right holders should know what are the steps to take in order to be able to produce proof as to what is their own picture and what not. Today, this is mostly done by technological means. For example, non-fungible tokens, IDs, special technological protection measures that are embedded in photographs, and therefore you can identify whether your photograph is illegally used online or not. I think we have gone, one step further. However, what is sad is that we have not managed as policymakers, as organizations, as associations, name it, not to inform right holders as much as we should be doing. And that's why these events can be very useful. That's all I wanted to say. Thank you very much.
Thank you, Irini. Very important comments, extremely important. And thank you that you logged in from Greece and you are actively involved with our event. Let's see what we can do, but we can take it as a great support or one of the supporters of the Cypriot initiative here to implement the directive. Interesting also to know where Greece is so far as this implementation concerned. But okay, we can continue later. Irini, I want to move here and give the floor to Nenad. Probably he has something to ask or to comment. But I would like also to motivate a little bit a good friend, Achilleas Dimitriadis, or his right hand and assistant in his office, who is also following us. If they can comment and say a few words. You are very famous on the island, Achilleas, on this what we are discussing now. And the first event was also in cooperation with you. And if we see that you are online and you don't say anything, so we have to, you know,
you have to
say
challenge me. You have to challenge me, Marinos. And first of all, thank you very much. I think this is a great success. The participation has been great. The fact that Marinos put this together and the government is behind it, the executive, the law office, the Bar Association, the House of Representatives, I think in itself is great. I've seen a fourth generation photographer. At the end of the day, Sebuch, it's about you. It's this one person that presses that click, that makes that work, that generates art, that makes us happy. That's what it's all about. Of course, you get into things which are much more complicated and much more important, but at the end of the day, you are the creator. And it is because of you that this system of protection of intellectual creation has been set up. And the idea is that you should get fair remuneration for your work in order for you to be able to survive and therefore continue to create for the benefit of simple people like myself who enjoy your art. This is what it's all about. So Marino, thank you very much for throwing the ball at me, even at 5 o'clock while I'm still watching. I think this is a great opportunity. The fact that Marinos is doing cultural heritage for me is impressive. I bow to his persistence in putting this together. I know Marinos far too long to be able to say, perhaps the time he had much more hair than me, which is a really long time ago. But the fact that we have Marinos running this and pushing it on the level of intellectual creation, I think it's very important because we have now a depository somewhere where people can go and look for our culture, which is there, it has been put together, and people can admire it and, more importantly, learn and create themselves. So just throwing the ball at me, Marino, I'm still around. I have my hat on as the president of our association. I also do human rights, which is expression and intellectual creation, which is in my heart. Of course, copyright is how I make my living, and I am very strong and persistent about it. So yes, I'm here. I'm very happy. I want to congratulate you. We need to get our act together in Cyprus. We need to make the amendments of the law. We need to pass the regulations relating to the copyright law, which are still pending and which we haven't had the benefit of yet. But I think events of this nature are fantastic because they make people focus on the issue, deal with them, and more importantly, get timelines within which work has to be completed. So I don't know if I've bored you. I've spoken from the heart, Marino, as a friend, and everybody else as creators, and also as a copyright lawyer. But I bow to the creators who make our life so much more interesting and so much more worth trying to protect these creations, which is really what makes our life so beautiful every day. So thank you, Marino, all the best. And I'm definitely on your side in any way I can. So that's just about it.
Yes, thank you very much. But you know it, our success is because we have people around us like you, like Cebu, like Teresa, like Dimi, like all the other friends here, like Kostas from Greece, Skriabas Kostas, and of course Irini. Now I remember that we met some time ago, and that's what motivates us to move forward and do whatever we do here for the island. And I'm sure we will continue, and we will do something, and we will improve the situation here on the island. But thanks, Achilleas. And we go to Nenad. Nenad, you raised your hand. You want to ask something or make a remark?
Hi, can you hear me now? Yes. Okay. Hi, my name is Nenad Joncic. I'm coming from Digital Heritage Lab. I'm working with Dr. Marinos. I'm dealing with 3D modeling, and mostly I'm using photogrammetry. So I will ask you a few questions. First of all, if I produce a 3D model, have a copyright of it? And the second one, if I produce a photograph for that, how I can deal with this photograph? If they're used, is it copyright for them, or they are not considering like art, or how it's going with that?
Timi or Teresa?
So, just probably didn't understand fully the question, but so there's two issues with 3D printing. So one issue is when
I'm sorry, it's not about 3D printing, it's about producing a 3D model from photography. You take a set of photography and then you produce a 3D model. This is called photogrammetry.
Ah, okay. Sorry. So probably I'm not totally aware of that technique, but I see that Professor Stamatoudi is raising her hand, so maybe she can help you better than myself.
Thank you.
Yes, Irini.
Yes, well, that's a very basic premise in copyright law. You only get copyright protection only if a work is original. This has been confirmed by the case law also of the Court of Justice of the European Union. So if you're turning a 2D picture into a 3D model, there's nothing original about it. You, in fact, infringe the copyright in the original photograph. And you cannot do that unless you ask for the author's or right holder's authorization. It's as simple as that, I'm afraid.
Thank you.
Well, I mean, so I don't understand what technique is that. I would just add if there. So of course, what Professor just said is completely correct, and actually Article 14 is one of those provisions that now also clarifies that photographs of things that were already in the public domain are also not protected by copyright, because it's an idea of that some countries protected and gave protection to unfaithful or to faithful reproductions of works. So I don't know. I don't think Cyprus is one of those countries that would give neighboring rights to faithful reproductions of things, and in this case, pictures. But 3D would still be a different thing. I would say that, of course, that's correct if it's totally faithful and there are no neighboring rights protecting the faithful reproduction. If there is some creativity in the model, but not a, one thing is to put effort and technical effort in the creation of something, and another thing is putting creativity on it. So I would agree with Professor Stamatoudi that if it's using just someone else's works to do something that's just equal to it, but in a different format, that's of course no protection to it, and you would need permission even to do that. But if that technique is something creative in terms of adding something else to the picture, maybe there's some other options.
Okay, can I put you a little bit more in details? So it's basically, if I want to make a 3D model of the monument and I take the pictures of it and I produce a 3D model. So if it's just a 3D model, it's not protected. But if something is happening with this model and have some, let's say it's visible, you can go inside, outside, or it's spinning around.
I think a picture of so starting with the picture itself. So a picture, when we are taking a picture of a two-dimensional work, such as a painting, there's no creativity involved on that, because you normally are trying to just portray that as it is. When you're taking a picture of a 3D thing, there's different dimensions to it, and of course you can choose a certain angle and there might be some creative choices when you are doing a picture or taking a picture of something else. Of course, a monument is in the public domain. So in Article 14, what it says is that, well, faithful reproductions or faithful pictures of public domains public domain works are not protected. But again, if the picture is creative, and I guess with 3D works, there might be some creativity associated with the choice of the angles and etc. Then, if the picture itself is creative, then you have some right there on the picture, not even on the 3D model, or you can, the 3D model, if it's just replicating the picture, is in itself not protected, and the picture would be the one protected. But then I would open here this possibility for some creativity associated with taking a picture of the 3D artwork. But I see that Professor Stamatori is again raising her hand.
Before Irini gives an answer, I would like to comment and say that it's a little bit complicated, this issue here, because what's happening if I will create a 3D object, I will reconstruct an object of a monument, let's say Parthenon, from the wild, from images, from tourists, which are available on internet. So I search according to certain criteria, let's say a hashtag Parthenon, and then the location, geolocation, which is the monument on the hill of Acropolis. So, and I create the 3D monument, which is a three-dimensional data structure of points, X, Y, Z. The images are gone. I erase the images. Nobody can follow up and finds out if I used 1 million images, 2 million, 10 million of images for up to a certain level of accuracy, geometrical accuracy, or even 100 or 200, and from where I took this content. So, but I'm curious to hear also Irine's comments. Irene.
Let's take a practical example. Tour Eiffel in France. If I want to depict a 3D little statue in order to sell for tourists, and if that little statue is an exact reproduction in other dimension, of course, of the Tour Eiffel, this is not protected by copyright because there is no creativity and originality to it, according to my own opinion. The Court of Justice of the European Union said that original is a work if it is its author's own intellectual creation, which breaks down into 2 parameters. First, the author should have made free and creative choices, and second, should have stamped the work with his personal touch. Nothing of that is here. If we have a complete copy, an absolute authentic copy of the Tour Eiffel. If, however, a photograph wants to take a picture of Tour Eiffel, right, from a distance where it is not only the monument that is depicted, but also the context, the environment, this is 100% a copyright protected work. So this photograph is protected. Otherwise, photographers wouldn't be able to have copyright protection in the works if they depict monuments that were out of copyright, right? So it depends what you're doing. If now you want to do a model of the Tour Eiffel, which is an abstract model, for example, a bottle for a perfume that looks like Tour Eiffel, this certainly is protected by copyright because there is creativity involved in the way you have made this bottle to look abstract and not a lavish copy of the original document. And what Article 14 says, Article 14 does not say that whatever you take a picture of, for example, that is no longer protected, you do not have copyright, but only if what is depicted in the picture is the work as such and not something which involves creativity. So for example, if you have the painting of Richard Wagner, but that was not the painting we saw by Dimi, which is not protected, but it was the painting from a distance with a special lighting that had also included other things like the wall or a seat or whatever. That picture would certainly be copyright protected. The same applies to models.
Thank you.
Thank you very much, Irini. Next comments. There's one here. Yes, Elena Alonefti. Yes, please, the floor is yours. Elena, we cannot hear you. Can you please unmute?
Can you hear me? It's okay.
Yes.
Hi. I'm the president of the Directors Guild in Cyprus, and as a guild, we have been collaborating with FERA.
Elena,
yeah?
there is an echo, and probably your mobile or some speakers are next to your microphone. If you can please, yes, or turn off your mic.
Can you hear me now better?
Yes, now it's better.
Yeah, sorry, I had my speaker on the other one. Is that okay now?
Yes, please.
Yeah, all right. As a Directors Guild, we've been collaborating with FERA, the Federation of European Screen Directors, for the last 4 years on the copyright directives. For us, it's a mess because we are an organization, a non-profit body, and our committee, our board, none of us are lawyers. We don't know the language. We go to the meetings in Europe most of the time, and it is very, very difficult for us to understand what we need to do in order to be able to not only to get fair representation of our work and not to be our work not to be used by others, but also to be able to do work under fair use. Let's say if we are documentarians and we want to do research and we want to use image or letters or words or take whatever information out in the public domain, we should be able to know exactly how to do that without creating problems for the people and other people doing that for us. So I think a very huge thing that the European Union could do is to be able to find a language that would take us, the creators and also the legal people, and put us together so that we can understand what to ask, what to expect, and how we can get together to be able to solve all these issues so that it doesn't take such a huge amount of time, because as Mr. Marino said, and also Teresa and some other people, for the public to understand what they're allowed to do and what not, and why. Why shouldn't a person not use an image on their website? And even individuals and professionals do that, not just people, everyday people. There are companies and organizations that they take the information and they put it publicly, and they don't understand that this is not okay. They still don't, because it's like it's been done for so many years. So because things are changing, it's very important to do these kind of things that we do today. So congratulations to Mr. Ioannidis and all the team and the presenters that you're doing that, because it takes us a step further to understand what is going on. But I would, my request would be if we could have more of this and inviting, let's say, people from different countries to collaborate on how we can face these problems. I don't know, this is a question to Teresa. I don't know, when you deal with these issues and when you examine them, if it's mostly done between you as lawyers, or if you also collaborate with all kinds of people, so you're able to draft these laws.
Thank you, Elena. Okay. Can I go ahead, Marinos? Okay.
Yes,
I think you raised a very, very important question, and I've myself been raising this question for a while. Why don't we create this environment where creators and which are both creators and users of other people's contents, right? As a documentarist, you always have to use someone else's content, or is frequent that you use someone else's content. Why don't create an environment where the community of creators, or be it the community of users, is able to discuss what should be to learn, but also to create their common understanding of what should be fair in terms of using third people's works. So we do lack, of course, at the end of the day, we still lack decisions on what should be fair use. We don't have fair use in Europe. We have specific exceptions for parody, for incidental use, for caricature, etc. But what should be fair within those exceptions, what should be considered lawful within those exceptions? And I would like to call your attention to the fact that in the United States, where they have fair use, a group of law professors and associations have done that process. Especially, they started with documentaries of creating a common understanding of what should be legal. Because if you ask me as a lawyer, I will not be able to tell you every time what is legal, because I lack a decision from a court to tell me what should be the guidelines for that use. So one thing that the Americans did, and that this group of people did, and I think the EU should benefit from something like this, is to take the interpretation of the law on the ends of the creators themselves, creators/users themselves, and go to a table and look at those uses from the perspective of you as a creator and from the perspective of you as a user, and try to come up with your own understanding, irregardless of what the lawyers say. So I do believe that you are saying that you need more information in a easily friendly language, but it would also be good for you to empower yourselves and define between yourselves what you think it should be permitted to be done. Because the clauses, like the exceptions and limitations, they use very broad language and abstract language that still needs to be seen on a case-by-case basis. And I think it would benefit, it would be empowering for you to decide within your group of peers what should be permitted and what should not be permitted. And of course, going through a process of defining what should be, in your opinion, lawful, kind of this is called the best practices, defining best practices, and that you all adhere to it, and then you have associations and filmmakers, everyone signing to those best practices, and this could be a resource to then go to court and say, look, there is this interpretation that this should be fair or this should not be fair. And I think it would be very interesting for Europe to engage in that process. And the other thing that you mentioned, and I lost what was the second part, the last part of your question, was my association. So my association typically works from the user's perspective, although we might not want to create this division between creators and users. We have typically worked with nonprofits. For instance, we were one of the organizations that worked the most on the issue of the new education exception. And what we did is we organized the teachers. We work with the teachers' unions in Europe to see what in practice those things mean for them, and what are the obstacles, and what do we need from a legal perspective to answer to those obstacles. And I think, but we did this from an observer, a nonprofit, a civil society perspective, and then we use this information to try to advocate for laws that would answer to these concerns. So, and what we saw is that, for instance, the authors, as I mentioned again, like the industry was very present there, but the authors themselves, the artists, were not so present there. And I think that's a shame because, for instance, one of the things that I think the authors need is like direct remuneration rights to go to platforms and ask for direct remuneration, regardless of the contracts that you sign with your labels, with your film distributors, etc. So something that actually the Germans just implemented in their implementation of Article 17. But things like this, I mean, this is just an example of something that is very particular to the artists, to the individuals themselves, and that have an opposing interest to the labels or to the distributors of content, right? So you need these people also to come and raise their voices. So, I mean, let's make better. And I think, you know, if we are here talking about the Cyprus implementation, I think Cyprus should hear from the civil society, from the authors, and not just typically the copyright reforms tend to be centered just about these industries and not go and listen to the other people that are involved. And I think that's very important. Thank you.
Thank you, Teresa, and thank you, Elena, for the kind words too. This is what I thought by following the comments of Teresa is even in case the pandemic is over, by the end of this year, that we can have here on the island a one-day long event, and have Teresa and Dimi also, but also Irinia and other professionals from Europe and from Paris, from UNESCO, to share with us their experience and guide us also. It is important that the sector of education, that's the first level where the people have to learn. The copy-paste is good, but if it's legal. If it's not, then there is a problem.
Sorry, can I ask you if I couldn't raise somehow digitally, raise my hand to take the floor? And before concluding this seminar, because I guess you were towards concluding it.
No, Maria, we are not concluding. I just wanted to make a comment, and then of course you can have the word. The floor will be yours to make your comments also. No, this what I wanted to say is just to prepare the audience, but also our friends and speakers today, that another one event is going to come by the end of the year. We will take the initiative to organize it, probably here at our auspices in Limassol. And we're going to invite also people from UNESCO, from the European Commission, who are in charge of this directive, the Directorate General unit and so on, but also some other specialists. Why not also from the European Court? I don't know. We will see. Yes, please.
So I take the floor now, because
yes,
I can hear some voices in the background, but now no. Okay. So hello to everyone. I am Vicky Christoforou from the Attorney General Office. I'm the person responsible with the implementation, the harmonization, actually the legal vetting of the draft law that has been prepared by the Ministry of Commerce and Industry. First of all, I want to congratulate the organizers of this event and the very insightful speakers. It's really a new thing, this a new and an old, because protecting in online content, it's not a new on European level. Now what it does, it takes it to another level because of all this digitization that took in progress, and we have all this content online that it was freely available and there was no protection of this content. So now there are the mechanisms provided under the European Directive to, let's say, protect and provide some, let's say, means of remuneration of all these artists and content creators that they have not been able to receive this, the proceeds of their efforts. I want to, we have already mentioned in the Attorney General speech that the draft law is before the Attorney General office. Actually, I'm dealing with the legal vetting, and it is quite a challenging effort and task to implement this directive. No, it's been like 2 weeks almost that we were still discussing with the European Union Article 17 in a specialized workshop within the Council Working Party for Intellectual Property Rights. And thank God they provided this communication with the guidelines how to implement Article 17, because there were so many question marks about proportionality, how, let's say, you impose these measures in small service providers, and how do you impose even fines on these service providers, because it's not an equal battle if you have Google on one side and a small service provider on the other side. Google has already this mechanism for screening and let's say looking into the content, and there were so many questions, and actually this was really important for us, this communication. As one of the speakers said, only eight European countries out of the 27 have harmonized their legislation or have passed their legislation. Actually 4, they have passed their legislation fully from their national parliaments. We have asked the European Commission to be lenient with us because of all these discussions, and due to COVID also it hasn't been easy. I do agree with Teresa that this directive and these laws have to do with the creators and all the whole industry, and it's very important to have their opinion. As I gathered from the ministry, they already had their preliminary position. But I have to say, because we are, thank you for this seminar, because it's an opportunity to actually listen to the interested parties and get in touch with the reality of the situation. We have Mr. Sebo in front of us. He's a photographer. He's one of the creators, which is quite nice, and UNESCO organization, the representatives here, the person that is creating the 3D models, all this. And I might say that we had Google approaching even the Attorney General office, stating their views, because it seems like the consultation with the private sector has not been really concluded or thoroughly be done. Why? First of all, there were all these discussions for Article 17, which is it was quite a task, and also due to COVID restrictions, we couldn't have all these meetings in place in order to make this feasible. Having said that, I'm approaching towards the end of preparing the draft to go before the Council of Ministers, and so we are. We hope that this bill is going to be before the Parliament by September, even earlier, and is coming together with a big package because, as Achilleas Dimitriadis mentioned, that there are some also regulations awaited for the works and the responsibilities of the Committee of Intellectual Property in Cyprus. And this committee actually under the new law has even more responsibilities because it's the national authority for dealing with anything that has to do with the collecting societies. So they had to be rewritten as well because this directive is imposing not only the responsibility of the collecting societies, but it's also imposing more, it's creating more work for the national authorities that regulates the work of the collecting societies. Anyhow, that's about it. I wonder, no, it's not about it. Regarding the protection of photographs, we have, our legislation had already online the reproduction of any copyrighted material, including photography, without the permission of the creator. And that means even the successors of the creator, and even after the 70 years they've passed, so if you're still alive and you're the successor of the original photographer, then you still have the rights on remuneration. So you need to have that in mind. And also, they can only illustrate your photographs, any photographs of your father, only by asking permission. Even if it's our legislation, it provides that if it's going to be, let's say, illustrated, a certain photograph illustrated within a seminar or for teaching purposes of school, then they have to mention who's the photographer, who's the creator of this art. And yeah, I'm wrapping up saying thank you so much. And I'm here for any more questions.
Iggy, thank you very much for your intervention. And of course, for your full support for the success of the event today. In any way, we need to collaborate. And I think it's our duty to inform the society here in Cyprus and the sector of education or academia is one very important area. And here we are. And I think we are going to have you, or we will like to have you in the next event with us together. But we still have a few minutes. I will let the event running until 6. It's interesting what we are hearing here. And if there are any other comments or remarks or anything else to be asked, here is the moment. And please. Raise your hands. Stefanos, yes, please.
Hi, everybody. My name is Stefanos Kouratsis, and I'm a photographer, photojournalist. First and above all, I would like to congratulate you for putting all this together. It's quite interesting. But there is a very specific question that comes to mind. Just count right now how many artists and creators are present and how many participated. That leads to the point where artists and creators are not fully aware of their rights, how these work and should work in Cyprus. And at the same time, we're coming to a point where decisions are made by bodies like the parliament, for example, with artists and creators being out of the picture completely, or suddenly finding out, look, there is this law that is about to pass. So we are not educated. when it comes to this. I have a couple of more notes. Yeah, the right holders have no clue what is happening or why or how to protect themselves, their legacy, like Cebu's father or grandfather pictures. So we're not educated. There are just fragments of artists trying to find out what is really happening. And there's a long way for that, at least in Cyprus. Thank you.
Stefanos, thank you too. We are a university here, and one of our duties is education. Second is research. Third is innovation. And the fourth is society. And that's our duty and the task for the society, what we are doing today. We are collaborating with a lot of photographers, not with you, of course, but we are looking forward in the future with Cebu, with some others here in Cyprus, and with the Society of Cypriot Photographers. And the event is in collaboration with them. And that's how it came, and how we involved, of course, other people like Achilleas' office during the first event that we organized, and then Wikipedia and Teresa with her association and so on, organization. We do our best, Stefanos, and step by step, gradually, we will manage. We are a small island. We are fully isolated from the rest of the continent in the middle of the sea. We don't know everything, but we are moving in that direction, slowly. But I would like, because I got a message from Teresa. She has to leave. She has another appointment. And I would like to say, Teresa, thank you very much. That's the second time that we're collaborating together for the interest, for all the help, for the support, for your time, and for your presentation and advice that you are giving us each time. We're looking forward, Teresa, to see you at the end of the year. Let's hope with the pandemic, things will be changed in a positive direction, and we have you in person here in Cyprus, in Limassol. And Stefanos, I don't know where you are located.
Nicosia. In Nicosia, Cyprus.
It's not so far away as Teresa, yeah? And we do hope to see you at the next event here in Limassol, yeah? Because for some Cypriots, even Limassol is on the North Pole, and they are not coming, yeah? They don't find the time to come and meet us in person. So
that'll be great.
We had more than 150 registrations online under Eventbrite, but we went, I think, up to 60 online today. This is what it is. We informed everybody, Stefanos. We did our best. People are busy. People are, running at the moment because the market is free at the moment here in Cyprus. So, Teresa, before you go, thank you very much again, yeah? And I hope to see you soon in Cyprus.
Thank you so much, Marinos. I would love to go to Cyprus. I'm sure it would be a very interesting event, and I would love to visit the island. If I can just probably say a last word on this issue of consultation. I think, we are all understanding of the delays that the COVID pandemic has caused, and the constraints that it has caused to meetings and conferences. But I think the member states, and I would advise Cyprus not to rush the process now when it has a draft ready and can still provide the public with an opportunity to provide feedback on that specific draft. So authors, educators, researchers, cultural heritage institutions, I think they should be given an opportunity after the draft is released to provide feedback on that draft. So some sort of form of public consultation should definitely take place to ensure that the process is complete and is inclusive and is representative of all voices. So if I can say one last thing would be that do not rush to the final step without a public consultation on the draft. Okay, that's it. Marinos, thank you so much for having me. It was a wonderful event. Bye-bye.
Thank you, Teresa. Thank you for being with us together this afternoon. Thanks a lot. Best wishes and stay healthy, yeah? And best wishes for nice holidays. So, any other comments from any other participants? Stefanos, your hand is still up, is raised? No? So, nobody else? No other comments? No remarks? So then I think we are coming to the end, and it was an interesting webinar. To hear also the voice from all the sides, to know where Cyprus is at the moment so far as this directive concern. It is a fact that Cyprus is moving. We are not stuck, and that the professionals in this area, as well as the policymakers, but also the Office of the Attorney General, the Parliament, and so on, are interested, and there is an activity. We as a university, and within the framework of our duty to the society, we will follow up. It is extremely interesting because, as it is our name, we are UNESCO chair on digital cultural heritage. So from the analog, we have to transfer it to the digital. And of course, out of that, to do what? Research, innovation, to create innovation. And then to hand over to the market, or to, let's say, create knowledge. It is extremely important for us, and this transformation, or the digital transformation, and it's a must. We will continue, and we will continue with all our collaborators, and I'm sure that we managed today to have more followers in our social media, but also in our activities and supporters. And I do hope at the next event, more organizations will come and join us and be actively involved. Sebu, I see you raise your hand. If you want to comment, say something, please.
Yes, I would like to comment on a positive note that with my experience, as I have a lot of friends all over Europe as photographers and in other creative content creators as well, dancers and everything else, I can say that at the moment, Cyprus is one of the pioneering EU countries regarding this legislation and regarding other matters as well. And I'm very proud that we are together today, even if as a small number compared to, let's say, how many creative content artists there are here in Cyprus. But this is a start, and it's a very positive start. And it started with me 2 years ago with Mr. Marinos, when I met you, and look where I am now. I can actually have, let's say, I can have a tool where I can protect myself, and I can protect even more my friends and my family when it comes to this. And I would like to thank Mr. Marinos, and I would like to thank everyone who's been working all this time. And reading from different things, this has been a pioneering thing for Cyprus and in the EU with me. So I would like to thank everyone, and thank you, Mr. Marinos.
Thank you, Sebu. Thank you. Thank you. Stefanos, you are hearing, yeah? It was not a propaganda, yeah? That came from his heart. Join us in our club here, yeah? In Limassol. And let's move Cyprus a step towards a positive direction, yeah?
I would love to meet you all guys at some point in person with the next meeting. It will be quite interesting to move things finally forward in a bit better movement, stronger, because people in general, as you all know, at least the Cypriots one, are a little bit more calm down. Things need to move a little bit faster to do things and protect, besides work and everything that comes with it at the end of the day, and not just ourselves or our intellectual property, but at the end of the day, the next generations. That's it.
That's all about, Stefanos. Exactly. That's all about it. It's up to us what we can do about this. Yeah. So I received a comment here. As I mentioned, the event is recorded, and as soon as it is processed, we will have it online and make it available for everybody. Yeah. So that's also from my side, and I would like to say once again, thank you to everybody, and wishing you the best for the upcoming holidays, and keep in touch. You will hear from us soon for a follow-up and for an updated version of the event. Let's help Stefanos, Sebu, and all of you, those who are in charge for the directive on the island, to have it the soonest, the fastest possible implemented. Thank you, Anne, once, wishing you a nice evening. All the best. Thanks.